Hi, folks. Clark Atterbury here. Welcome. I'm so excited to have you join us today. As you know, I'm a financial advisor, president financial advisor with Atterbury Investment Management. For the last 30 years, we've been helping people to manage their investments and work toward their financial goals. And so this is I've learned, if there's one thing I've learned in the last 30 years, is that people aren't investing just to accumulate money. They're investing for a reason, for retirement planning and for their spouse or for their kids. So I'm very excited today to be able to bring some fantastic information to you that really applies to all of us. And that's on the subject of estate planning, wills and trusts, and avoiding probate, minimizing taxes, trying to make sure that the kids don't fight when we pass away. And really, whether you're in a situation where you're thinking about leaving things to your next generation, or if you're in the situation where you're dealing with your parents, the previous generation, setting up things to leave to you, I think you're going to find some great information in this interview. So again, normally we talk about investments, retirement planning, managing investments, this sort of thing. Today we're going to talk to you about legal matters, and I have a very special guest I want to bring on. I want to introduce to you Paul Rabalais. Paul's a dad to 5. He's the founder of America's Estate Planning Lawyers, LLC. He's also an attorney with expertise in estate planning and the federal tax system, having earned his master's degree in tax law from Boston University School of Law in 1991. Welcome, Paul.
Hey, it's great to be here, Clark, and looking forward to having some fun here today.
Yes, indeed. And for those of you joining us, if you're watching live, we invite you to pop in your comments and questions. And if you're watching in the replay, then hopefully you see us addressing other people's questions. So what we're going to do, by the way, if you're watching us live, is we're going to talk. I'm going to pop some questions and topics out to Paul to share his expertise with us all. And then periodically we'll stop and look at comments and answer your questions. So if you put up a question, don't be discouraged if it takes a little while to get to it. We'll get to them all. If you can put a Q : before your question, that way it's easier to find questions if there turn out to be a lot of comments. So Paul, one of the things that I hear clients talking about all the time is how they can reduce their taxes. You know, we work for years and decades to build their portfolios up, and nobody wants to be given half of what they've worked and sacrificed for all those years to the IRS if they don't have to. So can you just share with us a little bit about why people estate plan with tax minimization in mind?
Sure, be happy to. And I think a lot of people just make this assumption that there's going to be this big tax burden on their family when they pass away, just because they're used to paying income tax and property tax and sales tax. And so they just assume there's going to be another big old tax that applies when they pass away. But really, in reality, for most people, it's in many cases a almost or completely tax-free event. So let me expand on that a little bit. Yes, many of you here who are watching this have at least heard of the federal estate tax, and yes, it is a 40% tax. But for people who pass away in 2023, the first $13.61 million in assets that they have is exempt from the 40% tax. And
Say that number again.
It's a big number. It's a lot of zeros with it.
How much?
13.61 million.
13.61 million.
Right.
And that's per
And the thing
spouse,
is,
right?
that's per spouse. So really, married couple under today's rules can really shield 27 million from the 40% estate tax. Now, so that affects just a very, 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 very small percentage of the overall adults who pass away every year. But that exemption is going to be cut in half, or is scheduled to be cut in half in a couple of years when this Tax Cuts and Jobs Act of 2017 expires, or as we say, sunsets. So then the exemption will be about $7 million instead of the current 13.61 million. But even then, married couples, 14 million. So most people aren't affected by that.
Right.
Generally speaking, an inheritance is income tax free. If you inherit a bank account from someone, or even a home or some stock, that inheritance is income tax free, unless, of course, you inherit a traditional IRA or retirement account. Whoever receives that will pay income tax. And there's this capital gains tax step up in basis. So even if you inherit appreciated assets, if you sell those assets, there'll be little or no capital gains tax to pay. So other
Got
than the
it.
big 40% estate tax, which applies to really relatively few families, there's not a real big tax burden on families these days.
That's great to know. Now, another thing you referred to, if a client inherits a traditional IRA, that's a taxable event, and that's one of the things clients are always saying: how can we pass that to the kids without paying taxes on that? And that might be more a matter of titling things properly than setting up a trust or a will or that kind of thing. And for those of you watching, if you should have a parent or someone leave you an IRA, if you inherit an IRA, you have an opportunity to take it as an inherited IRA versus just taking the money out and getting creamed in taxes right now. So, we have a family member who called up recently to ask about that. And the fact is that if they do it properly, they can defer taxes for up to 10 years more. Correct me if I say something that I'm wrong on, Paul, but I believe they had 10 years under the new Secure Act. They have up to 10 years to take all the money out of the inherited IRA, as long as they're taking required minimum distributions from the account along the way, if the person who left it to them had already reached the age where they had to start taking RMDs, right?
Yeah, how about that? Like we were chatting yesterday, I do a lot of research on the Secure Act and all these Treasury regulations. It's part of my job. And one of the goals of this Secure Act, which was passed just a few short years ago, one of the goals was to simplify the rules on required distributions. And quite frankly, I don't think they accomplished that because, you mentioned the 10-year rule for non-spouses, and then there's exceptions if beneficiaries are chronically ill or disabled or not more than 10 years younger than the beneficiary. And and then there's exceptions to the exceptions. But so we're still sorting all of that out. And so, yeah, that's had a big impact on our business and yours.
Yeah, yeah. And we'll come back to talking about titling a little bit later, and we're talking about trusts and so forth. Let's talk for a minute, in fact, about beneficiaries and naming beneficiaries. Again, we're not quite into the wills and trust matter, but what do you see when you're working with your clients? We, on our end, see people, when they create an account, typically when they name their beneficiaries. And a lot of people don't understand what's a primary beneficiary versus a contingent beneficiary. And I'll just share a little bit here for any viewers. If you've got a 401k or an IRA, any kind of an IRA, if you're naming a beneficiary, you have the opportunity to name a primary, and that says, if I were to die tomorrow, who does my money go to? And then you can also, and that might be your spouse. Maybe your spouse is the primary, but if you were both go at the same time, God forbid a car accident or something like that, then you can name a contingent or more than one contingent beneficiary and say, if neither one of us, me or my primary are still around, then who does it go to? So these are important things too, just titling the accounts right, even before we get to the attorney.
I think one of the things that you just said that kind of hit me and is so accurate is people designate their beneficiaries when they set up their 401k or IRA accounts. So it's almost done kind of in passing as part of the account opening process.
Yeah, in passing,
and then
right.
Maybe years or decades later, they go to an attorney and say, well, I want my estate to go this way. And then, so all these legal documents are prepared, stating how the person wants their estate to go. But really, all those legal documents that get prepared have no say-so over where the IRA or 401k goes. It goes to whoever was designated as beneficiaries on a quick beneficiary designation, perhaps years or decades earlier.
Yeah.
So really important that the lawyer and the advisor, financial advisor, work together to make sure all those designations, wills, trusts, legal instruments, they're all consistent with what that client is hoping to accomplish.
And kept up to date. You said they do it kind of in passing. And I can tell you, when I'm creating an account for clients, very often, they haven't given much thought to who they want for their beneficiary. And they go, well, I'll put somebody down. Can I add a contingent later? Or, can we update this later? The fact is, yes, you can update it later. You can change it anytime you like. But like you said, it's usually, I'm thinking about investments, I'm thinking about creating this, and I'm busy, got somewhere else to go, and they kind of do it very quickly, where it's terribly important.
Yeah, and we may talk about kind of the blended family situation, but it's, you have sometimes you'll have the old Brady Bunch family where each spouse had children from a prior marriage or relationship, but when the husband, fills out his IRA or 401k beneficiary, there's just not a thought to it. He just designates his spouse as his beneficiary.
Yeah.
So he dies, the $1 million IRA goes to that surviving wife. She has children of her own, and so the children of that IRA owner really wind up getting left out. So a lot of thought needs to go into these IRA designations. It just as much thought needs to go into that as the overall estate planning legal documents.
Yep. The other classic story, besides having a go to your new spouse's kids, is to have an ex-spouse that was named as a beneficiary 10 years ago
Yeah,
or whatever. You never updated it,
right.
you never changed it, you pass away, and the money goes to your ex-spouse, which is the last thing you probably wanted.
Exactly. Yeah, there's a lot of stories about some little bit of conflict that comes up when the family realizes that that was the case.
That's right. That's right. Let's get into more of your area of expertise and talk about what's a will, what's a trust. People ask the question: do I need a trust, or is a will sufficient? Can you talk about some of the basics in that area?
Yeah, it's probably the most frequently asked question that I get. What's the difference between a will and a trust? And look, we could go on for a long time, and there's a lot of different kinds of trust, but I'm going to kind of speak to it at its most basic level. Most people are at least familiar with the concept of what a will is. You see it in the movies, you see it in the TV shows, the old last will and testament of so and so. So there's really two ways to leave what you have to your survivors. One way is through your will. It's the traditional way. Sometimes I'll call it the old-fashioned way. You create your will, you leave all of your assets in your name, and then when you pass away, your assets, other than things like IRAs, which have beneficiaries, but if you own a business or real estate or stock, those assets are frozen when you pass away. And so your survivors, including perhaps the executor of your will hire lawyers like me. And since assets are frozen, we've got to go through a court and attorney involved process called probate, where judges have to get involved to sign orders that the will is valid. Inventories of assets are prepared and filed at the courthouse, and then judges have to sign orders ordering the banks and ordering third parties to transfer these frozen assets to the appropriate heirs that are listed in the will. But it gets done, but many people, rightfully so, perceive that as a very kind of difficult, expensive, time consuming, just kind of an all around hassle process. So the other way people establish things is they create what I'll call their revocable living trust. The concept there, they create a trust, and then their trust says who gets the assets when they pass away and who's going to be in charge of that. And then they transfer assets that are in their name. They transfer their home from John Doe to John Doe as trustee of the John Doe Trust, and they transfer their brokerage account and their business, their LLC interest or their stock. They transfer all of that to their trust. And the idea there is things that are titled in the name of their trust when they die, they're not frozen. Courts don't have to get involved. Lawyers don't have to get involved. That person who set up the trust will name what's called a successor trustee who really can instantly transfer those assets out of the trust to the appropriate beneficiaries or heirs without having to go through all the court and lawyer involvement. So when people say, what's the difference between a will and a trust? Yeah, there's many different forms of trust, but the question really is, what's the difference between a will, where you leave everything in your name and then your survivors go through the court process when you die, versus a revocable living trust plan, where you create your trust, title assets into it so they can be passed to your heirs outside of the court and attorney involved process. Hope that helps.
That's fantastic information. Thank you, Paul. And this is the kind of stuff people need to know and they ask about all the time. Couple terms that you and I know what mean, but our viewers might not. Can you talk about a trustee and a successor trustee?
Yeah, good point. So, every single trust has a trustee who's in charge of
Or
managing the
or two,
trust
right?
assets,
Co-trustees?
or two, sometimes
Yeah.
co-trustees. Yeah. who are in charge of managing the trust assets and just following the terms that are prescribed in the trust instrument. So if you take your typical John Doe and Jane Doe revocable living trust, John Doe and Jane Doe will typically be the co-trustees of that trust when it gets created, and then perhaps if one spouse dies, then perhaps Jane is the sole trustee of that trust during Jane's surviving lifetime, and then the trust probably says if Jane either becomes incapable or when she dies, many married couples will appoint perhaps one or more of the adult children to be the successor trustees to handle things after both parents pass away. And then the heirs are called, when a trust is involved, are called the trust beneficiaries. So when the parents die, that successor trustee or co-trustees is in charge of wrapping things up and making sure the assets get distributed to the beneficiaries, just like the trust instrument says they are.
And they don't necessarily get distributed immediately, right? Depending on the terms of the trust, it could be a long-term plan for beneficiaries of special needs children or what have you.
So yeah, what's popular these days? I'll go through. Many of these living trusts, within the terms of that trust, they have what I'll call subtrusts. So maybe a couple has a child who is really not capable of managing money, either because of a special need or just maybe financial immaturity. John and Jane might say, well, after we both pass away, for our son Fred's portion of the assets will remain in a trust for Fred for his lifetime or until he's 50 or whatever terms they put on it. And so, yes, oftentimes there's these subtrusts within the trust to provide for the ongoing management of assets for the benefit of beneficiaries. So that's a real common. In fact, probably the kind of I wouldn't say a new concept, but one that parents really like because of our kind of world that we live in, and sometimes children, marry and get divorced, is a lot of parents will set up what I call subtrusts for each of their children, so that if Linda Doe inherits, Linda's mature, she's responsible, but maybe Linda's 27 years old. And so the parents might say, well, when we pass away, we want Linda's portion to go to what I'll call the Linda Trust. And maybe Linda's the trustee of her own trust. But if Linda were to inherit $1 million in her own name, she might mix those assets up with other assets that she has with her husband. And then if they get divorced, she may lose some or as much as half of those assets. So Mom and Dad may leave Linda's part to the Linda Trust. Now all those assets at your office, Clark, are titled in accounts called the Linda Trust, which makes it far harder for those assets to get mixed up with other assets Linda may have with her husband. So if she gets divorced, she keeps her trust, and then Linda and her husband split up the other assets that they've acquired. So that's that divorce-proof aspect of leaving assets in a trust for children.
Fascinating. As you and I discussed yesterday, almost every family, it seems, has somebody who's got an alcohol or substance abuse problem, and so maybe you want to address that in the trust when you're spelling out terms of the trust. How that kid's going to get their money?
Yeah. I mean, I've dealt with tens of thousands of families, Clark, and I tell people I've spent the last 35 years trying to find the first normal family, and I haven't found one yet. So we're still looking, but yeah, if there is a substance abuse issue, sometimes parents will say, okay, I'm going to leave that child's portion in a trust after we pass away, and I want this other person to be the trustee. And if that beneficiary is an alcoholic, instead of putting an age at which the alcoholic child automatically gets the money, parents will often leave that up to the trustee to have that discretion to determine when that substance abuse child would receive the inheritance, because you just never know how they're going to turn out. They may get sober, they may relapse, and so a lot of parents like to leave assets to a child like that for the child's lifetime, but give that responsible trustee the discretion to determine, when that child is ready to have assets controlled by themselves.
There you heard it, folks. One great reason to have a trust, because if it's just a will, it's going to go to the kid and there's no control on it, right?
Well, technically, even if they had a will, in that will, they could include what's called a testamentary trust. and accomplish the same thing. But
Oh,
with the will, it's got to go through all the probate stuff before you can transfer it to the testamentary trust. If parents have a living trust, it's a much more seamless transition into that subtrust or trust for that child.
very interesting. Oh, a thought just popped in my head while you were speaking. I've heard sometimes clients call up and I'll say, who's the trustee or who's the successor trustee? And they'll use the word, well, so-and-so is the executor. Could you tell us the difference?
Yeah. If I had a nickel for every time I had to clear that up when people were talking about it, I'd have a lot of nickels. But yeah, I get the same calls where people say, "Yeah, my parents left me a trust, and my brother's the executor of my trust." And technically and grammatically, that makes no sense because the people who handle trusts are trustees. But when people do have a will, and maybe we'll get to it in a minute. When even if people have a trust, they'll also have what's called a pour over will. But in every will that people have, yes, the heirs are designated, but also who's in charge of handling that probate and handling that estate when the person who wrote the will dies. The Technically, the title of that position is called the executor. And so in some states, it's called a personal representative. In most states, it's called an executor. So in every will, you'll see a provision. Maybe if a person's married, they'll say, I name my spouse as my executor. If my spouse can't serve as the executor, I name this person or these people as the executor or co-executors. So one of the key points there in all of this is because sometimes people create these documents and then those documents sit around for sometimes decades. So important to list the backups. You're thinking, yeah, you'd want your spouse to handle things if you couldn't,
Right.
but naming, having a succession of people is really important as well. So having backups and covering some of those contingencies is important. But the executor is really a will term.
Thank you. That helps clarify it. I had a question, now I lost it. Oh, you talked about how these things may have been set up years ago, decades ago, again, just like the beneficiaries. How often or under what circumstances do you recommend somebody update their trust? Let's say they've come to you, they create a living trust. When is it appropriate to update it, or when do they not need to? I mean, does it not
Yeah.
necessarily period of time so much as it's something changes in their family dynamics or something? What are your thoughts?
Yeah, your question there reminds me of a conversation I had on Tuesday with a gentleman. He lost his wife about 10 years ago, and about 7 or 8 years ago, we set up his trust and his whole plan. He wanted things to go to his children a certain way, and he had a significant amount of net worth. He was kind of he owned his own business for many years, and had an estate somewhere between $5 and $10 million. But he's like, Paul, and he lived about 2 hours from me. He's like, Paul, I want to come see you, and I'm also going to have my financial advisor travel to come see you as well, so we can all have a meeting because if something's changed, if some laws have changed,
Hmm.
I want to update everything.
Hmm.
And so, I looked at this stuff pretty quick and I asked him a few questions. And what I really told him was, look, even though it's been 7 or 8 years, nothing needs to change just due to the mere passage of time. And so that's often the case. Now, there's a couple of circumstances where things do need to be reviewed and updated. So occasionally we get some law change stuff. Got some tax law changes coming up, and I don't even know that that's going to warrant many people having to change things. But the bigger reason for people changing things is a change in family circumstances. When they say, "Oh, I don't want this child handling things when I pass away. I want this child or these
Hmm.
children," or
Or
you know what?
changing who is your
Yeah,
successor trustee?
originally I left things to my three children. Now I think I'd like to include my grandchildren, or or I want to change who has power of attorney for me. So it's when people want or need, or maybe an heir has passed away and you want to update that. So we do remind people, hey, if any of these circumstances have happened to you, then we need to chat and make sure things are kept up to date. And those are, you change your mind, you acquire a significant amount of wealth. Those are the typical things.
If spouse dies, you remarry,
Yeah,
or if one of your kids dies and they're out of the picture
yeah,
and you need to change things. So more
yeah.
circumstantial than time based.
That's right. That's right.
Gotcha. Gotcha. Excellent. Thank you. What would you say, and this is big, and I know you could talk for a year on it, are the most common living trust mistakes?
All right. Well, when we talk about living trust mistakes, the one that is usually at the top of everyone's list is I talked earlier about the other than the will, where you create your will, leave assets in your name, and then your survivors go through the probate when you pass away. The mistake, if you could call it that, when people create living trusts is they don't what we call fund their trust, or they don't transfer the assets from their name to their trust. Because really, setting up a trust to avoid probate is really a two-step process. It's creating the trust and all of the customization that goes into who your trustees are, how your estate will be distributed. But then the second part of creating a trust to avoid probate is retitling those assets that would have had to have gone through probate if they were left in your name, retitling that home and that LLC membership interest and that stock, retitling that from the individual's name to their trust. And so it's easy to do, or perhaps after someone creates a trust and they go acquire a new piece of property, or they go open up a new brokerage account with you, Clark, it's so important that they acquire that property in the name of the trust or open that account in the name of the trust.
Mm-hmm.
So I somebody asked me the other day, Paul, I know you set up a lot of these trusts to avoid probate. What percentage would you say would those people who set up those trusts? How many of those people's estates end up in probate for one reason or another? And a wild guess is maybe 10 to 20% or so. And some of it's unavoidable. Of
And are
people who
those
set
the
up
ones
trusts
who
have
didn't?
some asset that's left out of their trust when they pass
They
away.
didn't. And to clarify, if anybody's watching this, if you've got an investment account with a financial advisor or other institutions, just because this, I run into this all the time. In fact, I have a client who's dealing with this right now. Just because the client meets the attorney, creates the trust, and lists things, say, I want these 10, 20 things to be owned in the name of the trust. That does not make it so. And that's what you're talking about, funding the trust, because you can list it all day long in the trust document, but if you don't come to the financial institutions and retitle those accounts, like Paul was just saying, it's not in the trust. You might have it listed in the trust document, but if you didn't retitle it with the financial institutions, it ain't so. Right, Paul?
Yeah, and that's why I want to kind of compliment Clark here. Clark's in that wealth management business where he knows his clients, he knows them well, he probably knows them better than any attorney that might serve those clients. So Clark and the other wealth managers out there, they're in a unique position to be able to assist and kind of guide and handhold through the estate planning process. Yeah, and I know, Clark, you're not in the business of giving legal advice and preparing legal documents, but we've kind of set up our business to really kind of insist that financial advisor gets involved, because they can play a big role and make sure these mistakes don't happen. So good to see Clark educating the investment world about estate planning, because so many of the financial advisors, wealth managers out there, to me, they focus so much exclusively on the investments and the retirement income, and they don't address the estate planning aspect. And I think there's a lot of opportunity there for attorneys and investment managers to work together, really for the benefit of all those clients out there.
That's right. Thank you, Paul. And that reminds me of something I wanted to point out to people. And I'm going to interject. We're going to come back and talk about other living trust mistakes. But one of the things that's unique for our viewers about Paul's practice, again, it's Paul founded America's Estate Planning Lawyers, LLC. And, I've been doing what I do, managing investments for clients, for 30 years. And over that period of time, clients will often ask us, do you know a good estate attorney, trust attorney? And we'll, give them a name or two and say, go talk to them, tell them we sent you. But In that 30 years, I've never once had the attorney say, hey, why don't you come and sit in too? And what's unique about Paul's paradigm, his practice, is that he's inviting the financial advisor to be involved in the process. So like you said, Paul, we've been working with some clients for 30 years, and so we know them, we know their families, and sometimes they think of us as their primary advisor. And if they're going to go talk to another advisor, an attorney or CPA, they sometimes want our input. And so in a situation like where they're coming to an attorney to create an estate plan, if we can help them navigate it so that you get the client, maybe husband and wife, maybe even their kids at some point in the evolution of it, and us to come to you and put all of our heads together. Two heads are better than one, right? Or three if we get their tax people involved.
And it's the bulk of people's wealth is in their investment accounts. And like Clark, we were talking yesterday. Virtually every married couple who has investment accounts has at least three, maybe more.
Yeah.
Maybe each spouse has a traditional IRA. Each spouse may have a Roth IRA. They may have
they might still have money in a 401k or 403b. Yeah.
And so it really that advisor needs to really know what's going on, because like we talked earlier, titling accounts, naming beneficiaries is a critical part of the overall estate planning process.
That's right. So I applaud you. I love what you've done with your model for your practice.
Well, appreciate it. It is a little unique. I'll take just a second to explain what we've done, but to me, it's exciting. Yeah. So I know some of you here may be watching on YouTube or Facebook, but I actually started making a few videos about 7 years ago, and kind of like you, Clark, you're a natural, and took me a little longer to be as natural as you are, but 700 videos later, a big following, hundreds of thousands of subscribers, tens of millions of views. I started getting some requests from all over the country. Hey, Paul, can I talk to you about my estate? And so about 3 years ago, I started this national estate planning law firm called America's Estate Planning Lawyers. We have our co-counsel attorney relationships lined up around the country. So if someone from California, New York, Florida, Tennessee contacts us, they'll work with me. We'll design the plan. We'll get the co-counsel participating in the particular state. And so we do all of this by Zoom. So it makes it easy for the financial advisors to join the meetings, since they're all done in a video recording. So it's exciting where we're going, and just having a lot of fun.
I love it. Thanks for clarifying that. And, in our practice, we work in many states. We're domiciled in California, in San Diego County in California, but many of our clients over the decades have relocated, moved to Arizona, moved to Texas, moved to Oregon, wherever, Tennessee. And so we are able to become licensed in other states and continue to serve our clients. So Paul, your situation is the same, right?
Yeah, it's very similar. It's probably not as easy for us to get licensed in many, many states. Some states have some reciprocity. Other states, you have to take the bar exam, which nobody wants to do. So,
you work with a network of attorneys, right?
Yeah, I've recruited and vetted attorneys in all the different states who are estate planning lawyers, and they participate with us, and gives us an extra pair of eyes to look at things, and it really works out well.
That's super. Just to explain to any viewers, again, whether you're watching the live or watching the replay, the logistics of that is, Paul is able to help people get the basics, get the big picture all set up. And if he needs to, work with a co-counsel in another state to bring them in to deal with perhaps some state issues. If he's not actively involved in that state, he's able to do so. So did I get that right, Paul?
Yeah, well, they have to participate, because we have to have a lawyer in that state participate. So they're going to at least review things, and if necessary, can answer any state-specific issues that may pop up.
Fantastic. What a great paradigm. I love it. So back to the most common living trust mistakes. We talked about the importance of funding their accounts, not just listing them on the trust document, but of funding them. What about selecting trustees and successor trustees?
Yeah, big one there. And I think a lot of mistakes get made because people will make a successor trustee decision when they initially create things, but sometimes family circumstances change. And so it's not only who will be the trustee, but when things go bad with a trustee, then you look to the trust instrument to say, okay, who can remove a trustee and who can replace a trustee, and is a trustee entitled to compensation, and if they are, what is that compensation? And so there's a lot of ancillary decisions along with just the who is the trustee that really need to be addressed in the customization of that trust instrument. I'd say maybe another often kind of overlooked scenario in the living trust is married couples tend to focus on, okay, who's going to get all the assets after both of us pass away? Is it going to be the children equally? Is it going to be some other method of distribution? Do we want specific assets to go to specific people like the home? But married couples often overlook the what happens when one of us dies decision. And so, like I tell people, after they give me the authority to be blunt with them, I may give them a couple of options and say, like, okay, in your trust, you can when one of you dies, that first spouse to die can leave all of their assets to the surviving spouse. The surviving spouse controls everything. It's simple. People like that. And then the blunt part is now the surviving spouse, though, could change the entire disposition of all the trust assets and exclude the children of the first spouse to die. And sometimes surviving spouses will do that intentionally, and sometimes elderly surviving spouses will get influenced or taken advantage of. And so some married couples like the idea of, okay, when one of us dies, I want my part of the assets to go in a trust for my spouse. But when my spouse later dies, I want what's left of my assets to
To go to my
automatically go
kids.
to my children. Yeah. So there's some really important decisions that married couples need to make. Not only what happens after they both pass away, but what happens when one of them passes away.
Can be complicated, huh?
Yeah,
Yeah.
it can be.
Yeah. You mentioned earlier that when you were talking about funding assets, putting a home in the name of the trust. Now, not everybody does that. Can you talk a little bit about whether or not, why somebody would want or not want to put their home in the name of the trust?
Right. So if the home just remains in, let's just say it's a single person for now to keep it simple. If that home remains in that unmarried person's name, then when they die, then that probate is necessary in order to either get the home sold so that the proceeds can be distributed to the heirs, or to get the home transferred to the appropriate heirs. Now, in most cases, you're looking at, months or longer and incurring expense and just a big delay. And sometimes the heirs want to sell it immediately, but they can't because they got to wait on the probate delay. So what a lot of people do is they transfer their home to their trust. And that way, when they pass away, that successor trustee, if it's appropriate, can put the old for sale sign right there in the yard, kind of the afternoon when the person dies, and that successor trustee can sell it immediately or transfer it to the appropriate beneficiaries immediately without having to wait on the probate process.
The assets. Yeah, I often tell clients, think of the successor trustee. If they come to me and they show me your death certificate, they are taking the wheel. They're at the helm. They're able to control things from the get-go, like say without having to wait or go through court and probate and that kind of thing. So interesting to see that applies to real estate too.
Yeah, and probably the biggest question we get from people about transferring their home to a trust is they'll say, Paul, I still have a mortgage on my trust, on my home. Is that going to mess things up if I transfer it to my trust? So, back in the late 1900s, 1990, I believe, somewhere around there, Congress passed what's called the Garn-St. Germain Act. And they made it a federal law that if people transfer their home to their revocable living trust, it doesn't, even if it has a mortgage, it doesn't trigger the due on sale clause, which requires the mortgage to be paid when a transfer is made. So people can transfer their home to their trust and it doesn't affect their mortgage.
And it's not a taxable event or anything like that.
Not a taxable event. No, it's just retitling to eliminate the probate process.
Thank you for sharing that. Let's shift gears for a minute here and talk a little bit about if somebody's got a real simple situation. Let's say I have a client who's a widow. In this case, let's say it's a woman who's a widow, and she has 2 kids, or 1 kid, or 3 kids, and pretty much their only asset is their home and their investment accounts that they have with us or elsewhere. If they're able to with their financial accounts anyway, name them as beneficiaries. If we're talking about an IRA, 401k, of course, it applies to insurance type of accounts too, 403bs, anything where you're able to name a beneficiary, then they can say, okay, well, I don't need a trust or even a will to say who gets that asset when I die. By naming them as a beneficiary, it says who's going to get it. And so I want to ask you, I heard one person say, if you've got all your accounts titled properly, and by the way, even the non-qualified, in our business, we refer to qualified accounts being all the tax-deferred ones.
Sure.
And you're always able to name a beneficiary on those. But even the non-qualified accounts, the individual account, the husband or wife joint tenant accounts, you can add a transfer on death, they call it TOD or POD, pay on death designation to these accounts, whether it's a brokerage account, joint tenant brokerage account, or your checking account at the bank. And that also says, okay, if I die, that's where it's going. Important to note, even if it's said in the will or in the trust, otherwise, the beneficiary overrides everything else. Correct me if I'm wrong or missing some insight there, Paul. But how you got the beneficiaries named overrides the rest, right?
Yeah, a couple of points there, kind of to your first point. I think what you were getting at is, and maybe to give you a little background, I think state legislatures across the country are realizing that, nobody wants to go through all this government bureaucracy when a family member passes away. So state legislatures are around the country are passing legislation enabling, years ago it was the POD for bank accounts, the TOD for brokerage accounts. Now you've got states allowing you to register your vehicle so it goes to a beneficiary through the Office of Motor Vehicles when you pass away. Some states have for homes and real estate, you're permitted to do a transfer on death deed. So yeah, you're starting to see more and more people, especially like you said in your example, just leaving all the assets to one, two, or three adult children who are all mature.
Yeah.
No reason for these sub trusts.
Yeah.
You're starting to see a lot more people be able to register things, title things, and set up beneficiaries in a way so that not only is the probate avoided, but it even lacks the necessity or need to have a trust and title ownership of things into the trust. So that's kind of what we have to do in estate planning is we have to look at each individual asset that someone has and try to figure out, okay, what's the simplest way to handle that piece of real estate or that business or that timeshare or those shares of stock in a computer share account or that brokerage account or that Roth IRA.
So I love your model. If we can all be putting our heads together for the sake of the client, it's got to benefit them.
Yeah, exactly. And in almost every state, except mine, Clark, the TOD and beneficiary designation controls ownership. We have some weird things in Louisiana, and the will actually overrides the TOD and POD beneficiary.
Oh, really?
In our state only. Yeah.
I was not aware of that. Well, see, folks, why you need to talk to an attorney like Paul. While we were talking about, a simple scenario, again, a widow, a few kids or one kid, and they said, look, it's not complicated. It's just going to my kids, 33%, a third each of them or whatever it is. I had another attorney tell me the flaw with that is, if mom dies, it'll go to the three kids. But what if mom becomes incapacitated? Who's going to act on her behalf there? This is known in the name of the trust. There's no successor trustee who's going to take the wheel and now be in charge. So let's talk a little bit about powers of attorney. Because I think if you add the proper power of attorney to the mix, that can address the incapacity issue. What are your thoughts?
Yeah, really, every adult needs to have these powers of attorney in place. But I will say when someone kind of creates their estate plan, let's say they did set up a living trust. If they have a living trust, some assets are going to be owned by that trust, house, business. And yes, the trust says if the trust maker becomes incapacitated, then the successor trustee can handle that asset. But that individual who became incapacitated also likely owns assets in their name, like their IRAs, for example, or their life insurance or annuities. And so the successor trustee can't handle those assets. The successor trustee, upon incapacity, can only handle trust assets. So
Right.
you have to have that commonly called durable power of attorney or general power of attorney, where you designate, okay, who's your trusted loved one that you'd want to make it easy for to be able to handle your money and handle your financial affairs if you get to a point where you can't handle it for yourself. Because if you don't have that power of attorney, and someone has $1 million IRA at your office, Clark, and they become incapacitated and they don't have that power of attorney, now the family's forced to go through that guardianship proceeding at the courthouse to have a judge declare that person incompetent, have a judge
Last
appoint a
thing they
legal
need when they're
guardian.
going through that.
It's a
Yeah.
nightmare.
Last
Yeah,
thing
it's
they
a
need.
nightmare.
Yeah.
Yeah.
So a few of the
So
scenarios we've seen in our practice, again, just in a simple scenario, I'll refer to the same woman and her kids. If mom should get dementia, let's say most of her money's in her investment accounts, and the kids are trying to take care of mom, pay the skilled nursing or whatever the scenario is there, and the bank account starts running dry, and they need to access the funds in the IRA account or the other brokerage account. But if there's no power of attorney, I can't take instructions from those people.
yeah,
I can
right.
only take it from the owner of the account if there's not a power of attorney. And if the owner of the account is becoming incapacitated, whether that's they got a car accident and they're in a coma or they got dementia, those funds are tied up and the kids can't get a hold of that money to take care of the parents.
Yeah, so that's why it's such a no-brainer. Why kind of every adult, any adult who owns anything ought to have that stuff in place.
Hearing that, folks, if you're watching this, get powers of attorney. And perhaps another time we'll dive into the difference between a springing power of attorney and a durable power of attorney. But I think in this case, you're talking about durable, right? Or general, like you said.
Yeah, yeah. I'll make a quick note just because I know our listeners. You brought it up. They're like, Clark, tell me more. um, that springing power of attorney is where an individual signs a power of attorney, but they're like, I don't want this agent that I name in my power of attorney to have any power to handle stuff for me until I've been determined that I'm incapacitated. So most powers of attorney are, instead of springing, they're immediate, where a husband may say, I appoint my having power of attorney, and from the moment husband signs that power of attorney, his wife has the authority. She doesn't have to prove that
Right.
he's incapacitated to be able to transact for him.
And I've seen it in our practice where the kids come to me and go, Mom's got dementia. She's in a memory care facility now, and I have a power of attorney. And they come in and they go, I want to tell you to sell some money because we need some money to pay the care facility. And we look at their power of attorney, and it's a springing power of attorney. And so we have to say, we need you to prove the incapacity.
Yeah.
In
Yeah.
in the document, it'll say you need 2 doctors to sign off on this or whatever it says. And
Yeah.
so then the kids have to go see get 2 doctors to sign off on it. And that's the last thing they want to be dealing with at that point in time. So that's the challenge with the springing power of attorney.
Yeah. In fact, the state of Florida years ago, they don't allow springing powers of attorney anymore. Every power of attorney must be immediate, and I don't know why they kind of led the charge in that, but that's their rule.
But on the other hand, before you name somebody your general durable power of attorney, you better make sure it's somebody you can trust, right?
Boy, you're not kidding. So
Yeah.
sometimes I'll see people say, "Well, let me think about who I should name as the agent of my power of attorney," and I named, my favorite son to be the trustee when I die, and I named my daughter to make my healthcare decisions, and look, I have this other son, and yeah, he's been in out of rehab, but I haven't given him a job, so let me just add it. Let me
We'll
make
make him the
him
power of attorney.
power of attorney. And I'm like, no, that's really the
No.
most important designation that you're making.
Ooh, that sounds like
All
a
of your money if you can't
nightmare.
handle yourself. So
Night-
yeah, that appointment is really important.
Nightmare. Hey, a couple of quick issues here. We don't seem to have any questions to bring up, so I'm going to go through a couple other things I had wanted to ask you about. I've had clients ask me when they gift assets from one generation to the next, who pays the taxes on that?
Yeah, it's another area where I think people are misled. And what a lot of people have heard is this, what used to be $10,000 number, which has been adjusted for inflation over the years. And for 2024, it's an $18,000 number. So But that is purely a gift and estate tax number. Some people mistakenly believe that if you give more than $18,000 to somebody in a year, somebody owes some tax. But really, a gift is never subject to income tax for the person who received it. It's not
Whether they
deductible
gave
by
them
the person who
18,000
made
or
the gift.
200,000.
Yeah. So if you make a gift of $118,000 to someone, what you did was the first 18,000, no problem. But that extra $100,000, nobody owes any tax. You have to report it that you made the gift on an IRS Form 709 gift tax return. But really, the only tax consequence is by making a gift of $118,000 in 2024, you used $100,000 of your $13.61 million estate tax exemption. So then if you pass away after the gift, instead of the first 13.61 million that you have, the first 13.51 million that you have would be exempt from the 40% tax. So it's gifting is typically not an issue for most, and it's certainly not a taxable event.
Great. Thank you for clarifying that. For those who are thinking, I've got a very simple situation, maybe I don't need a living trust. I saw one of your excellent videos talking about creating a handwritten will yourself in 20 minutes. Can you talk about that?
Yeah, I'm not sure if I regret making that video, but I made a video one time that says how to do a handwritten will in less than 4 minutes or something like that. And by golly, I think it's had 2 million views or more. But yeah, the reality of it is about half of the states actually permit handwritten wills that don't have to be notarized or witnessed, as long as you follow the validity requirements that your state has, probably maybe signed on each page, dated appropriately, maybe has to have certain language in there. And so in a handful of states, you are allowed to handwrite your will. But that's a fairly easy obstacle to meet. The problem is, okay, you handwrote your will, but did you write it in a way that it could be subject to different interpretation? I was involved in a court matter one time where a woman had cancer. It was a sad story. She was passing away. She sat down. She handwrote her will. She said, "When I die, I want my poor mother to have a place to live. I'd like her to be able to live in the house. But my husband also, I'd like him to be able to live in the house too. And my daughter, who's 21, doesn't have a place to live. So I'd like her, to have the house as well." So she died, and the three of them wound up in court trying to figure out who gets the house. And so it was a mess. It was just, the woman had the best intentions. She was trying to take care of everybody, but she just created a big mess that turned into a bunch of conflict.
I can see how that could happen. Now that brings me to the next related question is, a lot of people will go online and just get a document to kind of do it yourself. Oh, I'm going to download a living will, or you got these kind of do-it-yourself services where they just fill in the blanks on a boilerplate will or trust. I imagine that's rife with opportunity for screwing it up too, right?
Yeah, I mean, no question, technology is advancing. I haven't ever seen an AI produced will, but it's probably coming, and it may exist.
I bet you're right.
Who knows? But yeah, it's coming.
But it's better to have somebody who's got the experience to take a look at it and say, you better make sure this is clear.
Yeah, I mean, as we're talking about here, people are probably realizing that there's lots of circumstances where things could get missed, mistakes can be made, and so while people who do this electronically, it may work out fine. People who have maybe an attorney who's well versed can often catch things that software is never going to catch. So it's an important enough event that you just want to make sure you get it done right.
I know in both of our businesses, there's an evolution, or some potential clients who want to do it themselves and avoid paying our fee. But I know in our business, our value exceeds our fee, and I would say the same thing would be true in hiring a competent estate planning attorney.
Yeah, I'd like to think so. And I've been doing this for 30 years. I'm still learning new things every day. So
so somebody's trying to do it by doing a quick Google search is probably asking for trouble.
Well, it's just the ordinary consumer doesn't go through all of this on a regular basis. So it's such an important matter that has a lasting impact on the family. We just want to make sure people get it done right.
One other quick question I'm going to ask. I know this could be deep too. We don't want to go too deeply into it, but sometimes people come to me and they say, "I've got these assets, but I want Medicaid. I want to qualify for Medicaid. So let's give these assets to the kids." I know there's laws against that. What's your experience with people asking you about that?
Yeah. Oh man, it's a big topic, and so yeah, the idea there is, someone may have worked hard over their lifetime. They maybe have a house that's paid for. Maybe they have a few $100,000 of life savings, and all of a sudden they realize that if they go into a nursing home, that if they have maybe three or $400,000 in investments or bank accounts, that they're going to have to spend that money on their own skilled care. Nobody's going to pay for that. Medicare doesn't pay for that nursing home care.
Right.
The system is set up so that if you have assets, you've got to consume those assets before not Medicare, but Medicaid or
Kicks in.
Medi-Cal will
Yeah.
kick in to
Right.
pay for that long-term care. So what some people do, it's a big field, and in the legal community is people will transfer their assets either to children or to trusts for the children. The key there is, in order to kind of quote unquote protect those assets, they have to be transferred out of your name at least 5 years, or in some
Right.
cases 3 years,
The look
prior
back.
to applying for Medicaid. And so, yeah, you can't do this stuff at the last minute. If somebody has a stroke and they're going into the nursing home next month, they're just not going to qualify for Medicaid, because on the Medicaid application it asks, have you
Yeah.
made any transfers out of your name in the
In the
last
last so
three
many years.
three years or 5 years? And if the answer is yes, there's a penalty period where you're going to be stuck having to pay for that for many years.
Gotcha.
So
Thank
it's a
you,
big
Paul.
field, yeah.
Well, we could go on talking for hours, but we've been going on for nearly an hour, and I got a few other things I want to share with clients. I want to let them know that Paul has a website, and it's loaded with great information for you. And let's see here. I want to show you this. It's AEPlawyers.com, America's Estate Planning Lawyers, AEPlawyers.com. So you can check out a lot of information and great resources on Paul's website. And we also talked about all the videos Paul has done. So I'm just going to give you a quick peek at Paul's YouTube channel. And I want to point this to you. It's youtube.com/@America's Estate Planning Lawyer. You can see it there. You can pause the video if you want to see this, but it's right there for you to know. Or just search America's Estate Planning Lawyers
There you go.
or Paul Rabalais, and you'll find his YouTube channel. Also want to let people know about our, whoops, oh, got to make this work here. About our website. It's Atterbury Investment Management, and let's see, where'd that go? Oh, it's not. Oh, I got it hiding underneath there. I think. Let's put this under here. I think that'll work. There we go. ClarkAtterbury.com is our Atterbury Investment Management website. I also have a link here, the Once Hub link here, that if anybody wants to take a peek at our schedule and schedule a time to talk about investments, retirement planning, investment managers, things that we do, that's how you would do it. And that Atterbury Investment Management has a fledgling YouTube channel also. We've been going for a little over a year. We're just building our YouTube channel, and you'll see investment related topics on here: retirement planning, managing your investments, things that are of interest to long-term investors. And having